I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
Filing my cases shouldn't be that difficult. There's got to be an easier way.
Nothing frustrates me more than having to wait for my attorney to call me back. I need them now.
What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
Welcome back to the Zona Law podcast. It is a new year. We got a new podcast studio, and unfortunately, we have a lot of the same headaches that we have coming from 2020 onto 2021. And with that, let's get it kicked off. I'm Mark Zinman. I'm joined here with Scott Balua. Scott, always a pleasure to have you here.
Yeah, thank you again for inviting me back. Happy New Year. Happy New Year to everybody that's out there. We're looking forward to having a great year coming up in 2021 and hopefully reversing some of the course that we've set during 2020.
That's exactly. New year, good things to come. And I should say that while we're sitting here trying to get adjusted, beautiful new studio, I kind of feel like Ricky Bobby, not sure what to do with my hands. So if you see my hands go up in the middle, let's just ignore that and move on to the legal education here. So what we want to get into is everybody knows CDC moratorium has been extended. We'll kind of go through that and explain the nuances. As well, we sent out a newsletter last week that our Supreme Court, Arizona Supreme Court, came out with an administrative order requiring attorneys to put additional information, requiring all landlords to put additional information into their eviction complaints. So we kind of want to talk about those two things together. If you want to kick us off with the CDC, I think that'd be very helpful. A little background and where we are today.
Sure, absolutely. So, and if many of you out there that have received our newsletter already know that there has been an extension of the CDC order. It now runs through January 31st, 2021. All the expectations are is that there's a possibility that it'll get extended beyond that. But what is the CDC order essentially? So if you have tenants in your property that are having difficulty paying rent, then the CDC order allows individuals to continue to remain in the property as long as they make certain attestations and that they say that they make a certain less than a certain amount of money, that they're seeking rental assistance, so on and so forth. And many of you are already familiar with that. But the main thing that we want to focus on is that you can still move forward in filing non-payment of rent cases. You can still move forward on non-compliances and immediates. If there's health and safety risks, criminal activity, any of these other types of issues going on, you still go ahead and file. Isn't that correct?
Yeah. The CDC order says is if you have a tenant that's delinquent in rent, if they sign a declaration attesting to these 5 things, that they're not to be evicted. Now, what the CDC has said is that means that they're not supposed to be physically ousted. In Arizona, our courts have basically agreed with that. They're not supposed to be physically ousted. Some courts, some judges, though, are just saying, okay, even if you file, you're going to get your case pushed out. The majority of clients, though, are filing. You're allowed to file your non-payment of rent cases. Nothing wrong with that at all. Your immediates, your non-compliances will go all the way through judgment, and you can do a writ. It's not affected by the CDC. And then your non-renewal cases potentially will be impacted, and you have to look at those as more case-by-case basis, with the court telling us that if the tenant's delinquent and you serve a non-renewal, it's presumed you're doing it because of the non-payment, right?
Right. And so you just have to remember that if you're a property manager, your process really hasn't changed all that much. The only thing that you're going to want to do is make sure that you keep good records of communications that you're having with the tenant, because there is a provision in the CDC order that allows you to challenge the filing of that CDC declaration if you can show that there's a materially inaccurate statement in that declaration, that they haven't been making best efforts to make partial payments or to seek rental assistance. So that's the one layer of extra work that as a property manager that you have to do, is be more diligent about recording those communications between the landlord and the tenant.
And for us, honestly, with Zona, stressing to all of our clients, we can't stress it enough. This is the time you should be working with your residents as much as possible. We always suggest work with tenants, do your partial payment plans, any other arrangements you can reach. Now, though, is doing those, documenting your efforts. And if your tenant's blowing you off, if they're not working with you, that's when you do the challenge. And we work with clients on a one-to-one basis to figure out which one's really the tenant's making no attempt. And those are the ones that's warranted. And tons of times we've told clients that, it's not there. They just need to try and continue to work with their residents.
Right. The challenges to the CDC declaration should be the rarity. That's the extreme case. It's not the one where their tenant is a month or two behind on rent. Well, there still needs to be some workability. Accept those partial payments. Try to assist the tenant in collecting rental assistance where available.
Yeah, that's the intent of the CDC. So it actually came down to the wire at the end of last year, right? We had the CDC that came out in September, and then the stimulus package was the end of December. And there was a lot of back and forth, if everybody probably remembers, between the president and Congress. Ultimately, the president signed the stimulus bill, which extended the CDC. Right after that, then our Supreme Court came out with a new administrative order, 2020-229, and said what for landlords filing evictions.
So if you are a landlord and you have to go forward with filing an eviction, there's certain changes that need to be made to the complaint. Essentially, there's two new things that have to be attested to. The first is whether or not the landlord has sought rental assistance. If so, has that been applied to the balance? The other thing that you need to attest to is, Mark?
Well, this is whether you've previously got a judgment against that resident, which actually doesn't sound like that big of a deal. But if you think about it, you have to go back through all your files to make sure months ago that you haven't done it. The administrative order doesn't put a timeline on when you can go back. And maybe you've had this tenant for 3 years. Well, did you get an eviction against them 3 years ago? Now, the presumption is under the administrative order, of course, they're only caring about when the pandemic happened. They don't care about 3 years ago. But unfortunately, the language isn't clear on that. We always take the more conservative approach, which is, yeah, we got a judgment. You simply disclose it when you're filing your case, and it shouldn't affect anything.
Right. And there is no harm in doing that little extra step in going back into your file, because then you're becoming more familiar of what information you need in order to present to your attorney so that we can represent you well when it comes to the court appearance. Also, even before those changes came out, some judges were asking those questions anyway. Are you aware of whether or not a prior judgment was entered against this particular individual? Whether it would not rental assistance was obtained and also applied towards the balance. So, and it's just good to become more familiar, especially during these difficult times.
Yeah, and so what the court is looking at for both of these, actually, what they want to make sure is that the tenant isn't being overcharged and the tenant's not being double charged, for example. So if there was rental assistance, that the tenant got credit for that. For example, if in October, maybe the landlord got the rental property owners fund and got a check for $1,500. Well, that check should show up on the ledger saying, hey, tenant got credit for that, and they still owe the balance. Or if there was a judgment in October, and now you're seeking a second judgment in January, you want to make sure either the tenant paid off that previous judgment or that it's credited properly on the ledger, so you're not seeking 2 times the amount from October because you charged it in October and again in January. So I think I understand the intent of what's being done. Unfortunately, it's an extra information and extra burden for landlords that they're going to have to go through and really compile that. So we created a form for that, right?
Right. It's all compiled onto one sheet, so it makes it extremely easy. If you're a property manager, you just check through the boxes and answer those questions. And one of the questions that we've been receiving since we rolled out some of this information preliminarily is whether or not you're required as a landlord in order to seek rental assistance. There is no such requirement. It is simply asking the question of whether or not you have to. And some people, I understandably, interpret that to mean that, well, should I be doing that? Do I have an obligation to do that? No, there is no obligation in the administrative order to do that.
Correct. So clearly, under the order, unequivocally, you are not required to apply for rental assistance. Now, of course, it's a good idea. Anywhere that you can apply. But every client we've gotten says, well, do I have to? Is there something I should be doing today so I can file an eviction tomorrow? No. The order says you have to tell the court whether you have or not. So that's part one. The question of two is, okay, what rental assistance can the landlord even apply for? So previously, we had the rental property owners fund under the governor. The new stimulus package has $25 billion that's going to be going out to the states, and landlords will be able to apply under that as well. And so that's when you have to say, okay, I have or I have not applied. If you have to state whether or not you've received any money, and it just kind of flows of check boxes, right?
Right, so that it gives you a way of being able to easily make an accounting so that you can say to the court, yes, we have received this amount of money, this is when it was received, this is how it was applied to the account to ensure that there's not a double billing against the resident.
Yeah, and so then the separate question is, okay, well, if I don't have to apply, now I know what the court's looking for. What is rental assistance? Unfortunately, the administrative order didn't tell us how they define rental assistance. If our viewers and our clients may remember, housing assistance payment was defined for the partial payment statute before regarding like Section 8. So Section 8 is not a rental assistance payment. But anything obviously from what's going on with the pandemic, payments from churches, third parties, anybody that's paying the tenant's portion for them, I would note that as a rental assistance payment That could be from anybody.
So what if it's from a family member? What if they're the ones sending the assistance in?
I think you mark it. Like, there's nothing wrong with disclosing that you got rental assistance, right? You just say, tell the court, yes, we got rental assistance. The mom made the payment, and we credited them the $1,500. All the courts are looking for is to make sure that the tenant gets credit for everything coming in. Again, there's arguments why those things don't count as rental assistance, but the easier answer is be more conservative, mark everything as rental assistance, but for like the Section 8, and the reason that is, just from our perspective, is Section 8 isn't the tenant's portion. Section 8 owes that, and therefore that's not part of the tenant's rent, and therefore it's not rental assistance.
Right. In the circumstance where you have a property which is accepting rent through online portals, and you have it through, is there any affirmative to go and find out where that rental payment came from? Because a lot of the times the payments get submitted through these online portals, and you don't know necessarily the name of the person that's submitting it. So what in the circumstance, if there's a payment that's accepted that you don't know where, do you have to go those extra steps and find out where it came from?
I don't think so, because I think that then you'd have to go back years and try and figure out, delineate every single payment. Right. I don't think that's the intent here. I think the intent is when somebody's coming in, such as the Rental Property Owners Fund, and cuts a check directly to the landlord, and that comes in, they go, oh, we got the governor's funds here, and we apply it, and we give it credit. We got rental assistance, and this is where we go.
Right. The entire goal here, like you said, is that to just try to make the parties a little bit more diligent about the accounting of all these types of payments that are coming in, and just to make everyone cognizant that there is that assistance out there which is available to renters and to landlords, well, soon to be more to landlords. But that's kind of the goal of this entire process, at least I think that's the goal.
I don't think it's exceptionally hard to do these things. I do think, though, it's really what's being missed here is this is one extra burden that is being put upon property owners right now. It's being put upon attorneys. Ultimately, I'm not in a position to decide whether it's beneficial or not to residents. It ultimately will increase attorneys' fees. Unfortunately, we saw that last year. It's kind of just another part of that, which is unfortunate because the benefit in Arizona, obviously, is attorneys' fees are relatively cheap, which means that they're inexpensive, and so tenants are able to pay and reinstate their leases.
Right. There's a specific provision that as long as you get a 5-day notice, whatever late fees have accrued, and the base rent, as long as that's paid, you're a resident. You don't have to worry about any further action being taken, even through the point before a judgment's signed. A case gets filed, court costs, attorney's fees get accrued. You still, as a tenant, it's a pay, cure, you can stay, no negative implications associated with that.
Yeah, so if there's more and more of these things, I mean, eventually attorney's fees go up, and it's going to negatively impact residents as well, which is unfortunate. And so we're hoping that we work through the court with these things as future changes are suggested or made. But as of now, let's go big picture summary. So the CDC allows you to continue to file your cases. Non-payment of rent, though, may be stopped. You may not be able to go and get the restitution. Work with your residents.
Right. That's the number one takeaway here is that during this time, work with residents, put them on weekly payments, put them on something, and have like a legitimate basis for trying to work out those arrangements. If the most that the resident is able to afford is $100, $150 a week, you're going to want to work with the residents as much as possible to accept those payments and then avoid taking further steps.
Yeah, and on the administrative orders side, you're just going to have to give more information, a little more due diligence in terms of the past history of the resident, whether you filed for an eviction, whether you've sought rental assistance. And again, we've seen this question. You don't have to go get rental assistance, though, of course, it's a good idea. I mean, right. Take whatever money you can for the rent. You just have to be telling the court, yes, I have, or no, you haven't, and you go from there. We've sent out the forms. We'll continue to send out forms as things are changing. Right. It's always a pleasure to be here with you guys.
Right. And we'll be there for you anytime you have any questions.
We'll see you next time at the Zona Law Podcast.